India Confederation of the Blind. Training workshop on the rights of persons with disabilities with particular emphasis on the visually impaired for AICB affiliates in South India. Sponsored by Danish Association of the Blind.
If there is someone in the visual impairment sector, working in the visual impairment sector and has not heard of Mr.T.D. Dhariyal, then I would need to ask the question whether he or she is actually working in the visual impairment sector. He is a known name in the country and internationally. My association with Mr. Dhariyal has been more than 21 years. 21 years or so, when he joined as the Deputy Chief Commissioner for Persons with Disabilities. And since then, Mr. Dhariyal has never looked back. But not many would know that he has foregone 2 promotions in the ministry, only so that he can stay as Deputy Chief Commissioner and continue working for the cause of persons with disabilities, for the empowerment of persons with disabilities. He has personally sacrificed his promotions, 2 promotions, and nobody knows that perhaps. Very few people would know that. He was a Deputy Chief Commissioner, but of course, people who are working and committed, there's no short of work for them. So after that charge was over, he was appointed as a Commissioner of Disabilities, Delhi government. In both capacities, he has also been a consultant with CBM and many other roles, nationally, internationally, in which he has given very important judgments and done cutting-edge work. He has been particular part of AICB family. I had the pleasure and the occasion to argue several cases before him. He was objective, impartial, and yet very sensitive and empowering. Sometimes we used to have discussions and debates and arguments during the hearing, but that was part of the thing. But always very sensitive and very empowering. And a person who knows the soul and sensitivity of the visually impaired and persons with disabilities to the core, a real friend, a real well-wisher, a real mentor, a real guiding torch of the disability sector. Presently, the President, National Association of the Blind, for the Blind, Delhi. We welcome you, sir, to this and of course, a very close friend personally. We welcome you, sir, to the very important topic to deliver your lecture on legislations and policies concerning persons with disabilities in India, an overview. Request you to kindly deliver your talk for around half an hour to 35 minutes, half an hour, so we could have some time for interactions. The floor is yours, sir.
Really extremely thankful to Professor Aneja, AICB, Kaul everybody, the AICB family, Bikram Dutt-ji, for giving me this great opportunity to interact with a very enlightened audience. I think this was a very, very unique opportunity to be among you and talking. Professor Aneja has spoken too much about me, which I don't know whether I deserve, but still I'm so much thankful to him for saying so many words about me and my working in the disability sector. But one thing is that I had been all along a government officer. So I have been doing my duty that anybody should be doing, nothing special in it. But this has given me the working in the disability sector, whether Deputy Chief Commissioner or the State Commissioner Disability, or in the sector, NGO sector like NAB, Cape Foundation, or CBM, is a great opportunity for me. And in fact, the beneficiary is Mr. T.D. Dhariyal. So I have learned so much, and as regards Professor Aneja, Bikramdatji, these people are, I consider them as my gurus, because the introduction to disability sector, I was introduced to a disability sector by these people, and I learned so much during the whatever the hearings, as Aneja said, or our informal talks or discussions, or in fact, I would say this sort of mentoring. So with these words, I once again thank you, AICB, and all of you who thought that I should be given this opportunity to talk to you for half an hour. Although this half an hour is very limited period to talk on disability specific legislation, because our country, our government, and particularly the CSO sector, the disability sector, like Anejaji, Vikramji, and all others, have created 4 comprehensive legislations, disability specific legislations. That is Rights of Persons with Disabilities Act, which replaced the Persons with Disabilities Act 1995, Rehabilitation Council of India Act, National Trust Act, and Mental Health Care Act 2017, which replaced the Mental Health Act. So, so there is a huge amount of information, amount of work to be done, and so much to learn from each section that is there in that those 4 acts. There, however, I will be discussing issues or the provisions of these 4 acts, largely Rights of Persons with Disability Acts, from the perspective of the advocacy issues, because most of the participants, I'm told, are from the disability visually impaired sector, and I consider the visually impaired people in the disability sector as the pundits, right? So there is so much to learn from you. So I will not be going into what the provision and all this is, but a few things where there is so much to work for advocacy. Friends, I'll be basically focusing on Rights of Persons with Disabilities Act 2017, and I believe very strongly that awareness is extremely important for all of us to work and ensure that the people with disabilities are included in the society, truly included. It is not simply, making them sit in the, say, the child in the class or in a society or a function or something. So it is complete integration, complete inclusion in the society. That awareness must be created, and that is in fact under the Rights of Persons with Disabilities Act is the mandatory requirement for the governments, central government or the state government, to create that kind of awareness, to make people with disabilities and others, the right holders as well as the duty bearers, to be aware of what their rights are, what their duties are, to ensure that the people with disabilities get their rights. So one thing that we should keep in mind is that disability issues are all state subjects. Almost all the issues concern the states. So we have to do that advocacy before the state governments, of course with the central government, for also contributing to policy making at the central level, then legislation and so on and so forth, and ensuring, monitoring the implementation of the rights that the Act gives us, which is a great thing in line with the United Nations Convention on the rights of persons with disabilities. And the rights of persons with disabilities has been enacted to implement, to give effect to the rights to the UN Convention. UN Convention is so important that it is a unique convention so far in the not only disability, but I would say human rights arena, that we are very lucky to have ratified it and also harmonized. So there may be certain provisions still in our act which are not rights-based. There is a need to, really examine it, do a lot of research, and find out what are the areas which some areas have already been identified, not by activists like you, by people working in the disability sector like you, and also UN Committee on CRPD. The report is available online. They have pointed out certain things, that certain things are not rights-based. So we need to work on that and take up with the concerned authorities, particularly the state government departments and the central government. So that awareness and advocacy, I think the three, I always believe when we start doing advocacy or doing something, this is one is cooperation is very important, because a single sector, a single individual, single department will not be able to do it. It is a cross-sectoral, it is a cross-departmental effort that will ensure the rights of persons with disabilities. Now, when you do the advocacy, therefore we should keep in mind, that's what I believe, that there has to be cooperation among the disability verticals, among the people with disabilities organizations, and also the government and the NGO sector, private sector, and so on and so forth. That's one. That the different disabilities should not be talking differently. They should all come together and then move forward if we want to achieve something very tangible for every person with disability in our country. Then there is lack of coordination. It is not necessary that only the government will coordinate. You can make the government to coordinate, but then we can also contribute. We can also coordinate. We can also contribute to this coordination and then convergence. These three things I find are very, very important and often lacking, whether it is government or in our civil society sector. So with these three things, if we come forward, do that advocacy, I think wonders. I mean, a lot of contribution can be made. Now, the primary areas that need advocacy is the education. I find the education, if we can ensure quality education to people with disabilities, people with visual impairment, people with blindness, with the help of the latest technology that is available in the world, anything available in the world must also be available to us in India. So that advocacy needs to be done. How we can ensure quality education? Only admitting a child with disability in the class is not enough, or the university or the school or wherever. It has to be quality education, because this is another important thing is that it is, earlier we said integration. Now in the rights of persons with disabilities, we have mentioned about inclusion. Alongside inclusion, it is the choice of the child or the parent, that if a child or the parent, I believe, is provided education in inclusive or in a special setup, but that education is quality education, then that person with disability, especially people with visual impairment, will ensure their inclusion, will ensure find a path to ensure that they are included in society, to ensure that they get their rights. So key thing is getting quality education, number one. Then second, retaining them in the schools and colleges. That is the biggest problem. So we should not be only concerned about the enrollment, but also so that's one. That's education.
Vikram, if you could please mute yourself. There's sound coming. I think you're on the phone.
In the Rights of Persons with Disabilities Act, you will be happy to note that there are only 4 sections that are not mandatory. Rest all is mandatory. And when any provision is mandatory in any law or rule, it will be enforceable. Aneja ji would be able to explain it and tell us how it is mandatory, how it can be achieved. But I know that if something is mandatory, I can make the concerned authorities to ensure its implementation, to ensure provision of that facility. So, you know, in the Persons with Disabilities Act 1995, except education or a few other things, let's say reservation in jobs, or a few more things, rest all was dependent on economic development or the financial availability of financial resources with the state. Now it is not there. If a child needs a particular facility or equipment, or a person employed in an organization, irrespective of whether it is government or private, that reasonable accommodation, you may note, this is such a gift, I would say, this is a gift to the disability sector, to people with disabilities, that reasonable accommodation will have to be provided. And I believe, when I now after so many years of having worked in disability sector, I believe that as a person with disability, I need the level playing field. I need the entry to the hall. After I am in, provide me only the level playing field, that reasonable accommodation, then I will show that you don't need to, give me special concessions. I don't need special things. Persons with disabilities do not require special things. What they need is an opportunity. What they need is the reasonable accommodation. The definition of reasonable accommodation in the Rights of Persons with Disabilities Act is that it should not be disproportionate. I mean, the facility that you provide, the accommodation that you provide to a person with disabilities, the only criteria is that they should not be disproportionately expensive. So I remember the 2003. In 2003, the people in the government, various ministries of the government of India, they thought, oh, it's very expensive to buy JAWS software for people with blindness, or some other equipment, or some software, because the contribution is not much. Even if the person doesn't work, it's okay. Many people are frustrated. In the bank, in the offices, the people with blindness said, oh, they were allowed to mark their attendance and go off. So people did not realize that it is their dignity, that they want to work like anybody else in the society. So we organized a workshop in Vigyan Bhavan, and we said only the director, administration and joint secretaries will be participating in this from all the ministries, to see how practically the people with blindness were able to assemble a computer, were able to demonstrate how they argued and prepared for a case in the High Court or Supreme Court, how they typed, how a stenographer typed, and so on and so forth. So thereafter, there were a lot of changes. So practically, these things have to be done. Then comes the health. You see, there is a provision in the Rights of Persons with Disabilities Act that the health, in the matters of health, there has to be free or with little, I mean, depending upon your level of economic status, but the preference has to be there. There has to be a preference for providing health facilities. And I will also talk about the concerns on health and all this, or insurance. And Social Security, Section 24 very clearly says that whatever the facility, while providing the Social Security benefits like disability, it could be disability pension, it could be any other scheme providing cash benefits, cash transfers, or some equipments or some facilities. It could be house, it could be anything. So that is, while that is optional, that may or may not be provided by the government. How much the government provides is also the prerogative of the government. But once you provide to the citizens these facilities, the Social Security, the mandatory thing is that you will have to provide at least 25% more than to the rest. But this is only in the Act. Now we have to do that advocacy. Why we did not do that advocacy during coronavirus, when 1,000 rupees was given? I wrote to Ministry of Rural Development, I wrote to Ministry of DEPWD, Department of Empowerment of Persons with Disabilities, but no person with disabilities got that 25% extra. Everybody got, say, people who were affected by COVID were given 1,000 rupees. The persons with disabilities were supposed to get 25% extra, did not get. So this kind of advocacy, this is a very powerful provision. See, this is mandatory. If you give extra, 25% is mandatory. Then we come to say reservation in educational institutions. I think that is being provided, and there are not many complaints perhaps. The requirement, the need is to advocate for the children to be retained, to get quality education, and enough children with disabilities to be available for admission in the university courses. Professor Aneja knows how many seats are reserved for persons with disabilities and how many are available. The simple reason is the children with disabilities are not sent to school, and if they are sent to school, they drop out. If they don't drop out, the quality and they don't reach up to that level. So that we have to ensure that there is a provision. There is an effort to ensure that the children reach that stage. Then reservation. Now it's a very, very important for all of us that all those who are eligible for any appointment, the 4% reservation of 4% vacancies, it is, remember, it is vacancy based reservation. This vacancy based reservation was there in Group C and D, as you know, since 1967, and it was preference. 69 it was preference, and then later on reservation was there in Group C and D, 3% reservation, then in Group A and B, then promotion in Group C and D. Now we are talking about reservation in all. Of course, the law provides that the reservation will be there against 4% vacancies, irrespective of whether the post is identified or not identified. Earlier, it was only for Group C and D, but for A and B, it was 3% of the vacancies only in the posts which are identified in group A and B. The number of identified posts is also more. Then secondly, we should also probably advocate that which is already there, but it is there, it is not being implemented. What is that? The post may not be mentioned in the list of identified posts. A particular post by that nomenclature is not identified. And the note says that if similar work being done by somebody with disability, then that post should be deemed to be identified. So that thing is not being implemented. Another more important, I think we need to change our act. In fact, I was for it, but then nobody agreed for it. What is that? All the people with disabilities, all the people with blindness, all the people with whatever disability you say, may not be similarly able, similarly capable. A person with blindness may do so many things, all the others may not be able to do. So the act, I think, instead of identifying these posts, that we should open up. We should open up all the posts for people with disabilities. That is a major issue. I'm not going to debate on this or talk on this, but we should be thinking on that, because I have seen people with blindness, so many people with blindness or low vision doing so many things while others may not be able to do. So because somebody else is not able to do, majority is not able to do, a person who is able to do is denied his right or her right. So a person without both the arms are not there, who is in his 50s or maybe nearing 60. Somebody that he asked some tailor in the village of Gujarat, and he agreed to teach him how to stitch, how to take measurement, and that person without his arms is a tailor. So similarly, blind people have done wonders. You have seen so many things. We thought the blind people would not be able to work as a district magistrate, but I know Mr. Tiwari in Madhya Pradesh has done wonderful job as additional DM, additional district collector, in removing the encroachments. There could be so many more. So I think that is one. Another important thing in this area is the implementation of the rosters. The 4% reservation. People in the departments, in ministries, there is a lack of knowledge that we have to ensure that how many vacancies arose, how did the roster moved, whether each pointer reserved or not, whether the vacancy which was not reserved, which was reserved and for a particular disability, and when that person with that disability wasn't available, was it interchanged properly? Was it mentioned in the advertisement or not? These are very important things, because there we lose so many vacancies to, these get lapsed. It is not like for SC/STs where the vacancy doesn't lapse. So that we need to be careful. This is for the government. You see, in the Rights of Persons with Disabilities Act, two terms have been used: establishment, all establishments, and government establishment. Whenever there is a provision, whenever there is a mention of all establishment, that means that is applicable to all the private organizations also, which employ maybe 20 or more for equal opportunity policy, or let us not distinguish at this stage 20 or more or less. So it is applicable to all the establishment. Say, making places accessible, website accessible, information accessible, documents accessible, has to be done by everybody, all establishments. Equal opportunity policy has to be developed, has to be registered by all the companies, all the establishments, government or non-government. So these are very important things, where areas where we need to advocate, do the advocacy very effectively, create that awareness among them, and then probably ask them to do it. If they don't, then we have our grievance redressal mechanism. There is a grievance redressal mechanism in every government establishment. There is GRO, government grievance redressal officer. See that whether in your state, in your area, wherever you live, you are, wherever your organization is, whether this thing has been done, whether district level committee has been constituted, because district level committee is very important. All the issues concerning the discrimination will be going to the district level committee. Then whether equal opportunity policy has been framed and that has been registered with the state commissioner for persons with disabilities or the chief commissioner, and whether the information that should be available, that should be given in the equal opportunity policy is there. So we must look at that. These are the areas where we should be doing advocacy. Whether the website, some people should maybe it may not be a regular feature, but then just test check whether the websites are accessible, whether the documents available are in accessible format. If somebody wants something in Braille, that has to be provided in Braille. That is the requirement. Sign language interpreter, and so on and so forth. Then there is a, of course, state commissioner. State Commissioner of Persons with Disabilities, Chief Commissioner of Persons with Disabilities. No advocacy is happening here from the entire disability sector. Why don't we have the full-time Chief Commissioner? Why don't we have full-time commissioners, 2 commissioners in the Office of Chief Commissioner? Why don't we have all independent full-time state commissioners? If the state commissioner do not work, we can even go against them. So unless there is these people, our grievances will not be addressed. Then another area is that whether all the states have appointed, designated the special court for persons with disabilities. Because there is an offense, the trial will happen in that special court. That is not there. And then it is not only special court, but also the appointment of the public prosecutor who will fight the case on behalf of people with disabilities. These things, because we have in this act the very, very important and provision for the penalties, offenses and penalties. A person who contravenes any provision of the act can be fined up to 5 lakhs. Any person who intimidates a person with disability, insults a person with disability, can be fined, can be jailed. Any person who doesn't provide the information to the authority, say state commissioner or the chief commissioner, can also be fined. Haryana chief state commissioner has fined some 21 district elementary education officers 10,000 rupees per head for not providing information and denying promotion to persons with disabilities in their districts, respective districts. That is possible to do. So this is about Rights of Persons with Disabilities Act, and the Mental Health Care Act has been also been enacted with the view to harmonize it with the rights of persons with UNCRPD, but RCI and National Trust Act are yet to be harmonized. We should also do that advocacy. The RCI, which is responsible for ensuring registering the rehab professionals and ensuring the quality rehab professional courses, should also be harmonized. It is taking too long. It is too long. We are yet to do that. Similarly, National Trust Act You see, deaf-blind people or multiple people with multiple disabilities would need, say, persons with blindness having more disabilities, other disabilities will also be covered under the multiple disabilities. And the facilities, how many are taking, how many say deaf-blind, how many persons with blindness or low vision with other disabilities are getting benefit under Niramaya? Because that is a major issue, that health insurance is not being given to people with disabilities. So that is also a major area where we can we must advocate, do advocacy. So these are the areas of advocacy, and probably I don't know whether I have exceeded time.
That's okay. I think we can now have some questions, perhaps.
Yeah, now we can have question answer. Thank you so much.
Yeah, thank you very much, Mr. Dhariyal, for this very wonderful and very comprehensive talk. Mr. Swaminathan, you can ask your question which you asked me in the earlier session. Mr. Dhariyal has talked about having full-time commissioners in states and chief commissioner. You had a question on that. So how can we achieve that? That is the question Mr. Dhariyal, Mr. Swaminathan asked me earlier, that we want to have this facility, but what is the strategy for advocacy as far as trying to ensure full-time commissioners and chief commissioner concerned? Because Act only says have a commissioner or chief commissioner. It doesn't say full-time. So what is the legal way out? That could be one way. I think that's the one question that was asked earlier. Maybe you could respond to that. Mr. Swaminathan had asked that question. Yes.
Yeah, I have unmuted him.
No, it's okay. I have heard this question. What I would say, that I would ask for a state commissioner. You are right, Professor Aneja, that it doesn't say full-time, but then if they appoint a chief commissioner or a commissioner or a state commissioner who has double charge, say additional charge, his secretary as well as say commissioner, I should raise an issue that that a person, the same person, cannot adjudicate, the issues that are concerning his or her department. That is one. Another thing is, we should then put pressure on, suppose government says, no, we will have only the secretary who will function as state commissioner also. Then you raise all those issues, file complaints, and ask that person to dispose of those complaints within 3 months. If they don't, then there is a violation. So but
3 months clause is, but 60 days clause is not in the present act, right? It was there in the earlier rules. In the present act, it's not there, no, sir.
No, rules it is there. It is rules.
Okay.
Rules. In the rules, it is there.
Okay.
The same provision is there in the rules, RPW rules.
Okay.
Yeah. And for any discrimination, it is 60 days or even 30 days. If under rule, section 3.3, if there is any case that is gone to the state commissioner.
Right. So there are two hand raised.
But then first we should insist on having a full-time commissioner and tell them it's a commissioner, not the conflict of interest.
Yeah, that's a good point. There's a conflict of interest, surely. I agree with you.
Yeah.
There's definitely a conflict of interest.
Yes.
If the ministry, secretary MSJE is a chief commissioner, then the MSJE is also an enforcing body. How can they listen to the grievances against their own violations?
So
that's not
thing
right.
simple
Yeah,
thing.
that is a conflict of interest is a good point. Yeah,
when I was deputy chief commissioner, we filed so many cases. We against the Ministry of Social Justice itself.
Right.
So at that time there was no provision for penalty. We would have referred the matter to the special court, or we have penalized them. So
but even now, the commissioner cannot do penalties. It is under, as per section 84, the only special courts can give penalties under.
That is what I was discussing with this the Haryana commissioner. But I thought under section 93, if some authority does not provide me the information So I'll fine like RTI. So
Right.
there is no clarity on this. If you fine,
No, providing information is one thing, but 84 is clear for the penalties set forth under 88 to 93 or whatever.
yeah, it is very clear.
So for that, the commissioner order is not valid. You said Haryana commissioner fined, but that order you realize is not valid.
Like let's say, who knows, the courts may say, okay, because they did not comply with your
That's a
order.
different matter. That's a point of procedure. In the High Court, that would be quashed because it has not come from appropriate court of law.
But fortunately, all those people have deposited
That's a
10,000
different
rupees.
story, Mr. Dhariyal. That's a different story. But I personally like to be as correct as possible. Only then we can have an insulated chance of success. Yeah, I think there are two. Yeah, there are two people. Yes, sir. Two people have raised hands. Muthu and Aishwarya, please introduce yourself. Please introduce yourself.
Hello, I am Dr. Sivakumar from Tamil Nadu. I would like to know just clarification. Section 195 CRPC and 228 IPC. The Chief Commissioner or State Commissioner may take an action and report to some judicial magistrate under the CRPC 340. He cannot take any action those violation, criminal violations. But how can the State Commissioner or Chief Commissioner can act or safeguard for the persons with disabilities rights?
You see, the Chief Commissioner or the State Commissioner, when pass an order, give their recommendation. The good thing in this act.
Hi, Subhash. Welcome. Subhash has also joined.
I see.
Subhash, can you hear us?
Probably he may be muted.
Yeah. Okay. Mr. Dhariyal, please continue.
So that is why I am saying there's we have to do very, very effective, very aggressive, rather, I would say, advocacy for appointment of the special courts and the special prosecutors. When a good thing in this act is that when a state commissioner or the chief commissioner pass an order and make recommendation, the concerned authority has to comply, has to implement it within 3 months, or inform that it is for XYZ reason not possible. That is where I bring in what Professor Aneja said, that look, we would like to be as correct as possible. That is the best way. So that once these provisions, these authorities are in place, then I can ensure that these things are implemented or the violations are taken care of. I hope.
Is it over? Can I ask one question? Hello?
Yeah, please.
Is it audible?
Yeah.
Yes.
Yeah, I'm Srihari, retired professor from Hyderabad, political science. So
Yes,
I'm an activist. I'm not member of any NGO.
Yes, sir.
Can I talk?
Yes,
yeah, please go ahead.
Thank you for giving me an opportunity to speak to you and to participate in advocacy group. My question is, here in Hyderabad, the commissioner has constituted handicapped court with a retired deputy secretary person, and he is not conducting meetings at all, and hearing is not taking place, perhaps because of the COVID and other things. So how is it can commissioner, or she's in charge commissioner, is not full-fledged one, of course, perhaps can she appoint someone else and co-opt and constitute
No.
bench like this?
No,
Because
not at
They
all.
can't do that.
that's why, because I want to raise these issues because here the conflicts are not being resolved and not being heard here. So
No,
this way, in this way, it's
Professor sir,
working. Hello?
Professor Saab,
Yes.
And please go. Please go.
my suggestion in this case would be you file a complaint against the commissioner.
Okay.
Commissioner is also an employee. An employee of the government.
He's not independent. Yes.
And he is supposed to. No. Even if he is independent.
She's an employee. Yeah.
Okay, she or he. I don't.
Earlier she was deputy commissioner.
Okay. Whatever.
She's holding additional charge, perhaps. Yeah.
It will be chief secretary. If they are not doing their duty, then they are failing. They are contravening. That person or that individual, whoever he or she is contravening the provision of the act. Then you file a complaint. For trying that person. I would go to that extent. Why we should not be doing this? Unless we set this kind of examples.
No, please send it to us, the complaint. So our affiliate in Hyderabad, DWAB is our affiliate. Mr. Swami Nayak is there from there. Please write to us. We'll help you file a case in the High Court on this. Muthu, make a note of this.
First we can
Aishwarya and Muthu, please make a note of this. Because both are involved with our advocacy work. So this case we will take up. And please, Mr. Swami Nayak, send us a written complaint on this and documents. We will take up this issue in the Hyderabad High Court. Yeah. We have yesterday inaugurated our registered office also there. So we want to do some advocacy.
Type complaint and forward it to MuthuSelvi.
Mr. Swami Nayak.
MuthuSelvi or Swami Nayak, whomever it is. I don't have his number. MuthuSelvi's number I have. I can forward, I think.
Yeah, please do that. Yes.
Yeah, this is the way the governments will be forced to appoint full-time commissioners.
Okay, one more hand is there. I think before we go to Subhash then.
Yes, sir. So whether CCPD have a provision similar to Article 142 by which the Supreme Court has the power to look into the atrocities against persons with disabilities beyond the scope of RPWD?
No, it has the chief commissioner or the state commissioner can take up cases only which are within the ambit of the rights of persons with disabilities provisions.
Just to add to that, there is a provision for chief commissioner to take suo motu action. If a rights of person, and most of our rights are also repeated and granted again in RPD Act. So there are ways by which we can take care of any atrocity anywhere. If it involves a person with disability specifically, we can try to find a way to cover under the RPD Act if you bring it to our attention. We will try to, this is where our advocacy skills will lie. We'll try to twist and turn in such a way that it's covered under the RPD Act. And if it affects persons with disabilities, that's a requirement. Because anything affecting person with disabilities, we can surely argue it's under some clause or other of RPD Act. We'll try to do that.
Yeah,
yes.
I would also like to add, please have a look at the definition of discrimination. Discrimination, the definition of discrimination is so wide. It's very, very wide. And also the Supreme Court and other courts have number of times said that socially beneficial provision acts should be interpreted in the most expensive manner so that in order to achieve the objective for which that act has been enacted. So under that, as Professor Aneja said, we can bring in almost everything, and refer that matter to the, say, for example, it's a criminal case, refer to that particular forum. But then it's a very, very important and very useful that we have this kind of very, very extensive definition of discrimination in the Act. Everything will be covered under that.
Yeah, so I'm sure there will be other questions, but the time is running out. And so thank you very much, Mr. Dhariyal.
Aneja, can I ask a quick question to Dhariyal?
Oh, you can ask.
Yes,
Yeah.
yes.
Sir, Dhariyal sir, I'm MuthuSelvi, Vice President of All India Confederation of the Blind. Actually, I have this question on behalf of Tamil Nadu, sir.
Generally, actually, the state commissioner here, he doesn't want to use his this quasi-judicial power at all. So what happened was one of our affiliates, College Students and Graduates Association of the Blind. In fact, the person is here, the president is here, Raja. He filed a case on behalf of that organization, CSGAB, against one college, Hindu college. So 2 hearings, I think, it took place. So in the middle, what the commissioner office has said was somebody has filed a case in Madurai High Court, so we cannot tackle. We will see it you can see it in the court. So can it be is it the way to this thing, sir? Because the case was filed after their filing with the commissioner office in the High Court.
That is what we all have been doing, that if there is a case pending or has been also filed in the higher forum like High Court, generally the state commissioner would not proceed. But in few cases I have done, what I have done is, since the case has come to me, just because somebody has also gone to the High Court, I would not stop at that. I have passed orders, examined the matter, given my observations with a request, with an advice or recommendation to the complainant and the respondent to place these observations, these findings, my findings as state commissioner, to bring it to the notice of the High Court.
Okay.
That I have done. So that
Okay.
can be
Without even passing any recommendation or any advice or any order, they just want him to drop off and they just want to get away with that. That is
say, you see, but I think he may also be justified in not doing that. But then I don't know whether my action or similar action by other state commissioners would be right or not. Is also can also be a question mark, because when somebody has gone to the higher authority, in fact, High Court should be asking. High Court should have asked whether you have filed before the state commissioner. Let him first decide, then we will come to us.
That is the way. Alternative
the
remedies have to be exhausted first before going to the court.
So that I think.
Yeah. So there are 2 other questions quickly. Shiv Kumar, Anjana.
Yeah.
Please quickly, very quickly, because Subhash is there.
Yeah.
We need to get into next talk. Shiv Kumar and Anjana.
Hello, I am Dr. Sivakumar from state of Tamil Nadu.
Yes.
Good afternoon, sir.
Good afternoon.
228 of IPC has the power to any person who insult judiciary power have the officers. The officers can take action, criminal action may be taken, but our state commissioner or any case before you, any person who are sent to jail.
No, not yet.
But it has power, but nobody can do it.
No, you see that jail or any, as Professor Aneja also said, special courts have that power. For trial, you do not have, the state commissioners do not have that power.
Right. Anjana?
She is the advocacy officer of Kerala Federation of the Blind.
Who's Anjana?
Yeah, Anjana.
Good afternoon, sir.
Yes, Anjana.
Good afternoon, sir.
Good
afternoon, sir.
Yes.
I am Anjana BS from Kerala.
Yes,
I am
Anjana ji.
working at Kerala Federation of the Blind, Thiruvananthapuram as Advocacy Cell Coordinator, sir. The project is sponsored by AICB. Okay, sir. We are now doing major interventions regarding the disability pension scheme, which should be given 25% extra for disabled, as you mentioned. So we had given memorandums to the ministers and state commissioner for persons with disabilities. We hope that they will consider our request. Otherwise, what's the next step?
See, Madam Anjana ji, it's that 25% minimum, 25% extra is only in respect of the benefits that are given to all other citizens, right?
Yes, sir.
It is,
Yes, sir.
if it is a pension, disability pension, only disability pension or unemployment allowance for persons with disabilities, there you cannot say 25% extra. If they say all the people, say if there is a provision in the state that all the persons who are below this income level or below poverty line will get 1,000 rupees or XYZ amount, then we get 5% extra. Otherwise, if it is the disability pension only for people with disabilities, it will not be applicable there.
Okay, Mr. Dhariyal, then I'll ask a question.
Yeah.
A pension in afternoon superannuation as a part of duty, which is given to everybody. Should a person with disability be entitled 25% more there?
Yes,
that's given to everybody.
Yeah, that big.
But,
yes.
but is there social security? Do we call it social security?
Yeah, social security, because the people, why this has been incorporated is that the people with disabilities have some additional expenses, have to spend additional amount for the same services, and the Act section 42 clearly says the adequate standard of living. So adequate standard of living, like any other person, would need some extra.
Yeah, so we already have a case running in the High Court. AICB has already filed a PI in the High Court.
So nice.
Pankaj Chira is looking after that case.
Yes.
And we hope to achieve some good results in that.
Yes. In fact, everywhere, it is a old age pension. When it is old age pension, or if it is a widow pension, all these should have 25% extra for them.
Right. So thank you very much, Mr. Dhariyal. Really appreciate your very wonderful. I wish we could go on, interacting with you. You have so much knowledge, a depth of knowledge to share with us, and your vast experience. But we have another friend of yours who closely been working with you for many years, and somebody who is a part of AICB for a number of years. We have a member of AICB family, Mr. Subhash Vashisht, again a well-known name. He has worked with Swayam Foundation. Before that, he was with AICB. He's still with the AICB for that matter. Director, Cape Foundation, who would now, we've been talking about RPD Act. Welcome, Subhash.